Hello, my name is D'Angelo Wilson, and I will be presenting to you defamation in its research case study assignment. Part 1, New York Times versus Sullivan. Who are the parties to the case and what facts led to their dispute? The parties to the case is L.B. Sullivan, one of three police commissioners of Montgomery, Alabama, versus the New York Times Company. Mr. Sullivan, the commissioner, took civil action against the New York Times Company for defamation, claiming that he was libeled in a full-page advertisement within the third and sixth-page paragraph on the 29th of March, 1960, and was awarded by the jury $500,000 in damages as a result. The New York Times Company appealed. Why did Sullivan feel his reputation was damaged by the New York Times publication? During the 60s, the New York Times published their full-page advertisements paid for by civil rights activists, which openly criticized police operations within the city of Montgomery. Most of the publication was accurate, however, the publication also contained a few lies. In Mr. Sullivan's claim, the New York Times Company published an advertisement entitled "Heed Their Rising Voices," accused the police department for responding with waves of terror concerning civil rights protests and legal defenses for Martin Luther King, who had pending indictments of perjury. As a result from the statement made, Mr. Sullivan, the police commissioner, took action and sued the New York Times, arguing that the advertisement damaged his reputation, alleging that he was libeled. Reputation is everything for both private and public people. What are the elements of defamation? Since Sullivan was a public official, what did the plaintiff have to prove in this case? One must understand that statements made about someone to another person, third party, that causes one to incur scorn, hatred, ridicule, etc., is liable for defamation. As stated in Nolo, defamation is a false statement of fact and not opinion. There are also types of statements that are automatically called defamatory per se. In other words, statements about a crime, disease, or incompetence in one's career. In order for one to be held responsible for defamation, one must prove that the person made the statement acted with ill intent or negligently. The type of person is also an important factor, private person versus public person. The difference between defamation of a public figure versus defamation of a private figure is that a private person who claims defamation only needs to prove that a defamer acted negligently, while the public figure who claims defamation has to prove that the defamer acted intentionally and recklessly. In other words, since Sullivan was the police commissioner, a public figure, all he had to do as a plaintiff was prove that the defendant, New York Times, acted with ill intent or with negligence regarding the statement that were made. One thing to remember is that public figures are always in the light, so clearing up their name is easy, but for a private person, it's much harder. What was the Supreme Court's decision, and why did it make that decision? The Supreme Court, in a unanimous decision, ruled in favor of New York Times Company the rights to publish all statements protected by the First Amendment. Since Alabama at the time didn't require for proof, the Supreme Court ruled that Alabama court failed to provide safety for freedom of speech and of the press. Also, the court ruled that in order for a public figure to make a claim of defamation, there must be proof. One must show that he or she was acted on with malice, in other words, knowing that the statements made were false or with negligent regard for the truth. The Supreme Court ruled that the respondent, Mr. Sullivan, the police commissioner, didn't have enough evidence to support his claim, so the judgment of the trial court was reversed. To cut a long story short, New York Times versus Sullivan was a case about freedom of press. Even lies were protected long as malice was not present. During the 60s, civil rights movements were heating up. For instance, a full-page advertisement was placed in the newspaper to raise funds, signed by 60 well-known individuals throughout the country. Within the newspaper publishing, it was basically criticism about the police forces, describing them as waves of terror. The advertisement included true statements as well as false statements. L.B. Sullivan, one of the commissioners of police during that time, felt some type of way about the newspaper article, so he sued New York Times for libel. Sullivan said that even though his name wasn't directly in the article, the operation the police was aimed at and which damaged his reputation and was awarded $500,000 in an Alabama trial court as a result. The New York Times Company appealed, arguing that they had no intentions of malice, no reason to believe what it published was a lie, and to check all those members listed would have been definitely limiting free press. Unanimously, the Supreme Court ruled in favor of the New York Times for various reasons. One, being a public official, there has to be proof of malice or negligence to the truth. And two, when you are elected official, scrutiny from the public is pretty much warranted. You are always in the eye. You're always going to be judged. Now, on to part two. Who are the parties to the case? Was the petitioner a private person or a public figure? In the case of Gertz versus Welch, the parties are the victims of the cop who murdered their son and hired the petitioner, Elmer Gertz, a well-known attorney who was attacked by the respondent Welch, who publishes magazines. The petitioner, Elmer Gertz, was considered to be a private figure. What were the alleged defamatory statements about Gertz in the American Opinion article? During the 60s, the respondent who published the American Opinion Monthly started to put out information concerning a conspiracy to discredit police officers to create a force capable of supporting communist rulership. To support his stance, the editor of the American Opinion wrote an article concerning the case, Officer Nuccio, titled The Frame Up. Richard Nuccio and the War on Police claiming that the testimony was a lie and prosecution was part of communist schemes aimed at the police. What were the alleged defamatory statements about Gertz in the American article continued? Okay, according to the article, the police on file, the petitioner took a big Irish cop to lift. The article stated that the petitioner had been an official of the Marxist League for the Industrial Democracy, originally known as the Intercollegiate Socialist Society, which had been advocated the violent seizure of our government. It labeled Gertz a Leninist and communist fronter. It also stated that Gertz was even an officer of the National Lawyers Guild, described as communist organization that probably did more than others outfit to plan the communist attack on Chicago Police Department during the 1968 Democratic Convention. What was done to confirm the accuracy of these allegations against Gertz? Nothing was done to confirm the accuracy of the allegations against Elmer Gertz. The only thing that was done was the publisher supported the allegations by adding an editorial introduction stated that the author did extensive research in the case of Nuccio. He also included a photo in the article with the caption, Elmer Gertz of Red Guile harasses Nuccio. On top of that, he added insult to injury by placing the article on sale at newsstands throughout the country as well as distributing reprints in Chicago. How do you think these allegations affected Gertz's reputation? Based off these allegations, the American Opinion put out against him. Elmer Gertz had to have been impacted negatively as a lawyer and a citizen of the United States. During that time, such actions most likely would have warranted greater scrutiny than it would have been today. What would you have done differently than Welch to avoid the lawsuit? To avoid a lawsuit, I would have definitely checked with the author concerning the validity of the statements made about the petitioner. In an article covering controversial topics as such, the editor should have definitely looked into what was being published. That just lets one know, no matter the credibility or expertise one has, still look into what is being published. What is your state's defamation laws? Okay, since my state wasn't in the link, I had to do a search. Just like every other state, the defamation law is about the same. In order for the court to find that one has been defamed, communication must have been disclosed to a third party without knowledge or permission of the accused person. To cut a long story short, Mississippi defamation laws are the same as every other state, including all of its elements, for example, private and public figures. How can you relate what you learned from Sullivan and Gertz cases to your future work in communications industries? After analyzing both cases, I definitely took away, don't make statements about someone unless they are 100% true. I say 100% true for the reason of doing the actual research and work to make sure that one is putting out there and not just a lie or a mere opinion. From the Sullivan and Gertz case, I learned that if you are a public person, you will incur scrutiny no matter what, especially when one is constantly in the public eye, than one would be if there was a private person. I know now that one shouldn't put out anything that could hurt someone unless the information is solid truth. On top of that, one shouldn't put out anything with malice. Make sure the reason for doing something is valid and surrounded around good intentions. When it comes to the case of Gertz versus Welch, a boy lost his life at the hands of a Chicago police officer, so the family of the young boy hired a petitioner, Elmer Gertz, to represent them. Robert Welch, the owner of various publications, mainly the John Birch Society, published an article about the case alleging that Gertz was a testimony was fake and that he was a communist with goals of taking the police department of Chicago over. Just like in the first case, the victim of defamation filed suit against Robert Welch Court, invoking the diversity jurisdiction. At trial, Gertz was awarded and was determined to be not a public figure. However, the subject matter was a concern of the public, which made it where he had to show proof. The Supreme Court reversed the judgment of the trial court and granted certiorari.